What's up, everybody? And welcome back. I'm happy you're here. Hopefully, you're happy you're here. We're still talking about this Rust trial, days 8 and 9. It was a pretty quick end of the day on Monday, I believe it was. Yes, right. Trying to keep our days straight here. But today was a really interesting day. So we're going to finish up yesterday. We're going to talk about today and how it feels like a bit of a tale of two witnesses, is what I'll say, because the two main witnesses we've heard from so far today, one I thought was really, really good for the defense and very unusual for the defense to have that type of evidence in their favor to use from an unbiased third party investigation, even a government investigation, since they're going up against the government, that absolutely gave this jury something they can hold on to if they want to vote not guilty. So we'll talk to that when we get to that witness. But make sure you hit the like button first and make sure you subscribe to our page if you haven't already so you can be up to date on everything that we're putting out there and we can talk about this content together. As always, we're going to start with yesterday afternoon and we're going to hit the end of Seth Kenney's cross, and then they call Detective Hancock again. And that's going to be the bulk of what we talked about yesterday, because I did want to talk about how, or more, I should say, Seth Kenney's redirect, because we talked a little bit about how the defense was making a big deal about how much Seth Kenney had talked to Detective Hancock. And I said, pretty sure everybody was talking to Detective Hancock in this case. Everybody was trying to get their client or themselves out of trouble or charges to go away. And boom, the state hit that when they recalled Hancock. But first, let's hear Seth Kenney explain why he contacted Detective Hancock so many times and see if you guys agree or disagree. There were some mixed feelings on Mr. Kenney yesterday. So let's hear what everybody has to say about him today.
Asked some questions about how many times you called Detective Hancock. Why did you call her so many times?
Just to aid in the investigation, whatever she needed, or if I found something that I thought she might want to see, or if I had any questions. It was routine for us to be in communication.
Okay.
To aid in the investigation, basically, and see if she had any questions for him that he could answer. She also asked him some follow-up questions about, some of you asked yesterday, what's the big deal if you wanted to fire Hannah? And he talked about one of the reasons he wouldn't want to work with her again is because she had huge violations. Firing off even dummy rounds around horses is a big no-no. And they talked about how hard it would be to make a dummy round a live round if somebody wanted to sabotage them. Again, I think that's a pretty far-fetched theme for the defense. I've let you know what I think are their good arguments. That's not one of them. I really don't see sabotage as something, although I know a lot of you guys have had that at the forefront of your mind. Then she pulls Hancock on the stand again, the case agent, basically the lead agent on the case. She asks her, which I thought was a totally inappropriate question, what ways can you prove a negligent use of a firearm? It's like, that's for you to argue in closing arguments, Ms. Prosecutor. There was an objection, thank God, and the judge does not allow it because that's a total improper question for a cop who, frankly, is not even an expert on how stuff gets proven in court. They're wrong half the times about what people will be arrested for or what you have to prove or what the elements are. Not an expert, not appropriate testimony for a cop to give in a situation like this. They talk about Brian Norvell, who was one of the guys on the video who reaches his hand over the crime scene tape in the body cam footage that the defense seems to try to make a big deal about. They're like, did you ever interview him? Yes. Were all the defense attorneys there? Yes. Did they ask him any questions? No. So it's like, it does shed a little light sometimes when defense attorneys shamelessly point the finger at every single person they can, even if there's no evidence that they did anything wrong, even if there's no legitimacy to their arguments. Sometimes they just want to throw everything up against the wall and see what sticks. And at times that can be true about just about any criminal defense attorney in a case, because you have to try everything to zealously represent your client. But then she gets into, at the end of her direct, a question about, yeah, Mr. Kenney reached out to you, but so did Mr. Halls on behalf of Hannah Gutierrez, didn't he? And other people involved in the case. And this is exactly what I have felt has been put out the whole trial. They confirm it here, so the jury gets to hear it wasn't just Seth Kenney. I know some people may think he's shady. I may be one of those, that there were some I wouldn't say shady, but not great answers, or some dancing or floundering around, or just not remembering when you had your deposition taken. But he wasn't the only one reaching out to Detective Hancock here, trying to clear his name or his client's name. As we heard, some lawyers reach out to her as well. So let's listen to this exchange.
Were you present in the courtroom when Mr. Bowles asked Mr. Kinney approximately how many times he called you? And I think Mr. Kinney agreed it was approximately 40 times.
Yes,
How many times did Mr. Bowles call you?
quite a bit. Not just calls, but also emails and text messages.
Would you say it was more than 40 times?
I'd say at least around there.
And how many times have I called you?
A handful, maybe between 5 and 10.
All right, thank you. I'll pass the witness. Oh, sorry.
Turns out Mr. Bowles contacted her just as much as Mr. Kinney. And then here's cross-examination. Now I want to listen to the beginning because he comes right out with that.
Thank you, Your Honor. Now, Corporal Hancock, isn't it true that I'm representing Ms. Gutierrez-Reed in this case, and I called you and emailed you in that capacity?
Yes,
And Seth Kinney, on the other hand, is a potential suspect in the case, right?
according to who?
Well, you're the investigator. Did you ever look at him as a potential suspect?
Yeah, he was investigated.
Okay, so that's what I'm asking you. Do you normally talk to potential suspects that many times in a case?
I don't think there's a limit to how much we talk to them.
With regard,
So he's like, well, I only called you because I represent Hannah Gutierrez. She's like, okay. And you were trying to get information just like Seth Kinney. Seth Kinney doesn't represent anybody. It's like, yeah. So Francis said, but they're attorneys and Kenny isn't. It don't matter. Everybody's calling her for the same reason, to get information and to try to make sure the person they care about, whether it's themselves or their client or their daughter, doesn't get charged. So if you're going to hold pre-trial calls or conversations to the detective, to the detective against one person, you got to hold it against everybody. Anybody can reach out to a case agent, a witness, a suspect. Cops love when suspects reach out to them. They'll record all those conversations and use it all against them if they can. That's the interesting part. Is on one hand, you're going to argue, oh, they're using all of Hannah Gutierrez's statements against her, and she had just been through a traumatic event, and you can't really hold that against her. Yet they're saying it's unfortunate that Seth Kinney called you so many times. Well, it's like, well, if he would have said anything incriminating, we would have used it against him. That's how that works. Same thing with Baldwin. I see people saying in the chat as well. And then he kind of diminishes one of the tests she said she used, the barrel test. I didn't think it was overly impactful. And then the last witness of the day was Primo Forensics, analysis of digital media evidence, audiovisual performance. He zoomed in, enhanced, made some pictures and parts of pictures clearer, or snapshots from some of the videos. Honestly, I zoned out through most of this. I know he got paid thousands of dollars to do his expert work, but in my opinion, nothing groundbreaking there. That was just to show, in my opinion, the state wanted to say, look, we didn't manipulate anything. Everything was done with peer-reviewed, high-tech, mumbo-jumbo. That's all appropriate and above board. A lot of people are saying it's definitely sketchier that Seth Kinney reached out. Okay, that's fine, if you say so. If you think it's sketchier that Seth Kinney reached out as opposed to Hannah Gutierrez through her lawyer, because Hannah Gutierrez through her lawyer is still Hannah Gutierrez reaching out. Baldwin through his lawyers or himself is still that individual reaching out. And I think it's very interesting that Seth Kinney didn't get arrested yet. Some people think he's more culpable in the chat or something because he reached out to the detective versus Hannah Gutierrez, who they did arrest. You know, why wouldn't they arrest Seth Kinney if they found criminal wrongdoing? I feel like they would have. Baldwin, I get it. I get it that, some people think he's getting the star treatment, and I get it. And that does happen. We've definitely seen that happen before. Okay. So the state rests, meaning they are done. But because they have the burden, they can go first and last. So while they have finished their case in chief, and we are hearing the defense's case in chief, the state is entitled to a rebuttal case. So once the defense rests, the state can recall witnesses or call new witnesses to respond to and rebut anything the defense brings up. So you may think, what new things is the defense going to bring up? Well, in their first two witnesses, we heard it. The OSHA guys. People that Lee says peer-reviewed eye roll. It really is. you would be shocked what experts can get away with as peer reviewed. But it is, and those are the standards in most courts of law. So the first OSHA compliance officer is the one that actually did the investigation or led it and ended up giving the report with findings. Interviewed 7 people, including Hannah, Hall, Baldwin, Pickle, all the people that, were interested parties in this case. They requested the safety policies from the employer, and they gave him the safety bulletin involving firearms. In the citation, he cited Rust Movie Productions. Now, what's interesting to know about OSHA is, if you know about OSHA, they basically reprimand and find employers, companies, corporations for doing things wrong, that aren't safe, that are breaking protocol, breaking rules, breaking policies. They never deal with employees, okay? And we're going to hear some of that on cross-examination. But even knowing the truth about OSHA, this evidence is really great evidence that defense attorneys are not always used to having. So to have this guy call him and run through him, I thought they did a great job presenting him as a witness. We are going to listen to some clips of his testimony that, in my opinion, if the jurors are looking for a reason to vote not guilty and find that Hannah Gutierrez actually did not have a duty or was not capable of performing her duty, and therefore she could not have been negligent in causing the death of Helena Hutchins, this witness provided that evidence to them. Now, do they have to take it? No. Do you have to take it? No. But I always like to see, is there evidence, especially when we're dealing with motions for summary judgment, directed verdict, judgment notwithstanding the verdict, meaning no reasonable juror could ever have voted in this direction. And again, a lot of those happen in civil cases more than criminal. If it's not guilty, there ain't going to be an appeal for that. But I like to see, is there evidence that a reasonable juror, a good juror, a logical juror that is fair and impartial, has evidence been presented that if they look at it a certain way, it could be reasonable for them to vote not guilty? To me, this first witness provided them that evidence. So let's listen to some of it together.
Why did you issue a citation?
The citation was issued because, in our conclusions, we determined that the management team was responsible for a series of failures that, in our opinion, accumulated in an accident.
Okay, and by management team, who do you mean specifically?
Specifically, we mean the chain of command above Hannah Gutierrez, beginning at the lowest level with Sarah Zachary, and then Gabrielle Pickle, and then Dave Halls.
So did your findings...
So basically, Zachary, Pickle, and Halls all failed as a whole and as a team. The management people at Rust Productions failed. You know who's not on that list? Hannah Gutierrez. So I think it was really great that the defense had him point out specific individuals' names so that the jury knows that there are findings involving individuals, and Hannah Gutierrez was not one of them.
Then include any... So then your findings that you just spoke of, those didn't include Ms. Gutierrez, right?
As an employee directly engaged in the work, she is mentioned in the report frequently. But in terms of who do we identify as a member of management, and thus who do we consider responsible, she's not. She's just an employee.
Okay. And once you do your report and issue the citation,
And you start to understand why throughout the state's case, the defense kept saying, "Here, Zachary, you were her boss, right? David Halls, you were her boss. Seth Kenny, you were her boss. Production, you were her boss. She wasn't the boss of anybody. She was the bottom of the totem pole. Is she really supposed to stand up to Alec Baldwin, star, actor, and producer, aka her boss? You wanted to fire her. You wanted to fire her. Everybody wanted to fire her because everybody was her boss." That's why they want to talk about that. She is not management. She is an employee. The people in management that could have fired her, that were her boss, her direct supervisors, they are responsible, not her. That's what they're trying to argue here.
does the employer, the production company, get an opportunity to contest that?
They do.
And did they contest that in this case?
They did.
Was a fine ever ultimately levied against the employer in this case?
There was, yes.
What was that fine?
They came to a settlement agreement with the department at $100,000 even.
And in your experience, have you seen the state of New Mexico levy such a high fine like that to an employer for workplace safety ever?
I believe we have in the past.
So why is this a problem? I was waiting for this. she said, what was the fine? They settled on 100K. Have you seen this happen in the past, ever something this big? And he says, I have. And so I went back to my notes and I was like, wait a second. I thought in opening statement, they said this was the highest fine in New Mexico state history. That's how bad this is. And just to make sure I'm not crazy, we're going to take a look back to day one, just for one quick minute, to hear what they said in opening statement. Now, is it incredibly important? We're going to get to the next witness that talks about how this is the statutory cap is what they fined them, $130,000. They settled on $100,000, which is fine. The statutory cap, to me, not as impactful as the most ever in the state of New Mexico. So it all depends, right? The jurors might not remember this. They might not have even thought about this. But I think it's important that if there was a juror like me on there that wrote down the highest fine in state history, and then it turns out it wasn't, and other people have been fined like this, does the defense start to lose credibility? I don't know. That's why when I do opening statements, I'm incredibly careful. Incredibly careful. So let's just play it, see what he says, and see if it would be impactful, if they even remember, right?
Finally, you're going to hear from OSHA that Rust Production didn't adhere to several safety rules that they have to adhere to on set. That's why they were fined. They're given the largest fine in the history of New Mexico over this case.
They were given the largest fine in the history of New Mexico in this case. Stuff like that bothers me. You know, I just, that type of stuff bothers me. Like, why? You don't need to do that. Let's just stick to exactly what happened. They were fined 6 figures, the statutory cap, the most the state allows you to be fined. Words are important, right? To me. So that was a little bit of a, to me, but I get what they were going with, and it may have just been a misstatement. And we'll give them the benefit of the doubt at this point, but it probably would have bothered me just a little bit. Okay, so I'm going to skip ahead a little bit to hear exactly how he explains in his report the failures of management, which I'm surprised the judge let him get this in, because as I'm listening to it, I'm thinking there is a ton of hearsay that is coming out, and he is not an expert. So for him to be able to testify to the hearsay in his report as it not an expert, this was a little bit more than I think should have been allowed, but I think it was good evidence for the defense. 126. And before we hear it, I did want to talk about some of these points. OSHA almost always puts the onus on management. I agree. It's kind of what they're there for. I didn't think this was impactful. We already knew other people were responsible. Doesn't take away from Hannah's guilt. So I've been saying this all trial, Valerie, but I think this could potentially take away from Hannah's guilt. If they look at OSHA, which again, on cross, they bring up the fact that you guys don't do a criminal investigation, right? Right. But the judge let them put this information in there. And it seems like somebody's already made this decision, but they haven't. And that's why I don't think it was appropriate evidence, but the judge let it in. And I think if you listen to this and you're a juror and you hear that these professionals who do this for a living and are a government agency, they came to the decision that it was the responsibility of management, and they created a situation where Hannah could not do her job, removing her duty. It's absolutely a way to look at this. Not the only way, but a way to look at this. John said, so if Hannah felt uncomfortable with her job responsibility, shouldn't she just quit? Yes. Hannah not stepping down is negligence, in my opinion, especially dealing with the guns. So I do think she should have quit. I do think that's what some of the state's experts said, and she didn't. And again, these would be the discussions, John, that we would have if we were sitting back there in the jury room deliberating together. These are the types of conversations they need to have. But the defense is doing their job and at least giving jurors that might be on their side the ammunition they need to fight for them. No pun intended.
Whether Hannah was provided with enough time to inventory and inspect dummy rounds and blanks.
That was one of our conclusions, yes.
What specifically did you conclude about that?
May I look at the folder?
Would it refresh your recollection to review your report?
Yes, it would.
Okay,
Highlighted or?
page 7. Provided enough time to inventory and inspect the dummy rounds from her employer.
We came to the conclusion that she was not afforded time to conduct her duties to the best of her diligence.
And who didn't give her enough time to do that?
She had been instructed by Gabrielle Pickle to focus on other tasks.
And did you determine whether Rust had any process to ensure that live rounds were not brought onto set?
We determined that Rust did not have any specific processes or procedures to prevent that possibility.
And why was it that that was on the employer, in your opinion, versus the armor?
In that manner, the employer is asking an individual to perform multiple safety-related functions for them, while also telling them that they're spending too much time engaging in those safety-related functions and need to devote more time to other duties. And on that matter, we determined that to be a managerial decision.
Okay. And did you conclude whether Rust management provided the armor, Ms. Gutierrez, with any authority on training?
We concluded that she effectively had no authority to make any sort of training decisions.
And in your
So they didn't provide her enough time to do her job. They provided her no authority to take the steps or force the steps that she thought was necessary to make sure it's a safe environment. Okay, there's more. So Cleansed and Fire said, I don't think that takes the ability for her to shake bullets away, Peter. I agree with you. And again, this is great. I appreciate these comments because it makes me think. We're back there in the jury room. We're discussing stuff. You're bringing up something. I'm bringing up something. So if I'm the defense attorney in closing argument, if I know people like you have this question on the jury, what I would say is it does take that ability away. Because if she would have known that Halls was handing the gun to Baldwin, that Baldwin was rushing this blocking, that they were going rogue, going off script, doing things to test it, pulling it out without proper training, she would have had the time and ability to say, stop, I need to shake him again. I need to make sure it's a cold gun. Give me a second. I'm the one that's supposed to hand it to Baldwin. Halls, you hand it to me. I'm going to do that last safety check, and then I'm going to give it to Baldwin. But that's what I'd argue if I was the defense attorney. But if we're back there and we're in the jury room, I would say, yeah, but she never did that ever. There's all sorts of testimony that she didn't do that. That she wasn't always the last one with the gun. She wasn't always shaking the bullets, showing the actor before the gun. So was it really because she wasn't afforded the opportunity, or was it because she just never did it right? And those would be the discussions that happen back there. And Riri would say, yeah, but guess what? I agree with John. Maybe she shouldn't also be impaired. And this is why the state has brought up multiple different ways in which she is negligent. Ashley, it's her birthday today. Happy birthday.
Your investigation, was that failure to give the armor authority to determine training, was that a violation of any Rust safety procedures?
It was.
What was that a violation of?
Safety bulletin number 1. One of the required items is that the armor determines when training is necessary and if retraining is necessary based on somebody maybe mishandling a firearm.
Okay, and what evidence, did you see any evidence in your investigation about the armor, Ms. Gutierrez, attempting to attain additional training on firearms for the actors?
Not specifically attempting to retrain, to acquire more time for training into my memory.
Okay, and was that did the employer, I guess, did Ms. Gutierrez raise any concerns about not being provided adequate time to perform her armor duties?
Yes.
And what in your investigation was Rust's response to that?
Our conclusion was that those statements regarding not having enough time went unheeded and uncommented on.
By whom?
Gabrielle Pickle and possibly Sarah Zachary or Dave Halls.
Sarah Zachary and Dave Halls?
Yes.
Did you make any conclusions in your findings in your report about who the Rust safety official was on set?
We did.
Who was that?
Dave Halls.
And did you find any fault with anything that Dave Halls did?
So OSHA considers the entire management apparatus to be a single entity. And in this scenario, there are these 3 individuals who are part of this upper level of management. And Dave Hall's responsibility as a safety coordinator on set, we certainly found that there were a number of safety bulletin number 1 policies that were not followed or adhered to that would fall within his purview.
Okay, and were any of those pertaining to having the actors point guns at crew members?
That is one of the items in the safety bulletin.
And are you saying that Mr. Halls and Rust top level management were in violation of that?
Rust's management team did not take measures that were required in safety bulletin number 1 to permit the aiming of a firearm at a camera or the case may be.
So basically what they're trying to do is take all this duty that all these experts and everybody has said is on the armor, which is Hannah Gutierrez, and point it to Dave Halls, point it to management. I don't know that I buy that. But they're at least having somebody who could stand up there and say, I looked at their safety bulletin and they weren't following it, and it's on management to make sure their employees are following it. Now, the state's expert said it's on the armor to make sure that that happens.
Okay. And you talked a little bit about Rust not providing Ms. Gutierrez with sufficient time to thoroughly inventory ammunition. By ammunition, I mean blanks and dummies. Were there any findings with respect to Rust providing their staff sufficient time to inspect this ammunition to ensure there were no live rounds present?
No, our conclusion was they weren't afforded time.
And this is why you're seeing like OSHA always comes down on the employer, because it's like, you guys got to make sure this stuff that they have time to do X, Y, and Z. But at the same time, it's like individuals need to actually do their jobs as well. And she needs to inventory her ammunition and her firearms. She needs to watch that stuff. She needs to actually do what her job description is as the armor. Because this is kind of almost going too far and absolving her from like everything she would have done on set. So if she would have, again, shown up drunk or high, well, it's on management to send her home if she's drunk or high. And people are asking, was it actually proved she was impaired? There are text messages saying she was smoking the day before. And then obviously she gave the alleged cocaine to an acquaintance the day after. But, you know, that's inferred by the evidence.
Sorry.
And with respect to whether or not Rust production showed an indifference to hazards associated with firearms, what was your opinion on that?
The conclusion of the Bureau on that was based on the sheer number of requirements listed in safety bulletin number 1 that were either ignored or otherwise not at all followed or totally contrary in practice to. We found that Rust was willful. They were plain indifferent to the recognized hazards of firearms.
They were willful / there was plain indifference to the safety with firearms. And that is according to their own safety bulletin. So what do I always say? And so a lot of this, because there's so much negligence involved in this, right? And in this case, it's very similar to what we do in our civil negligence cases. If you have a safety policy, you better follow it. Because if you don't, that's basically locked and loaded negligence. Now, not having one, that's negligent. But if you have one and don't follow it, that could be willful negligence or plain indifference. Like you said, you knew it, you wrote it, you knew the rules, you made the rules, and you still didn't follow the rules. And that's what he's saying here. And that's what OSHA found. Jenna said, I work in workplace safety in Australia. It's really interesting to see how different the laws are. Here, the laws are all about the company and leadership responsibility, never individual employees. There are a lot of laws that are like that here, including what OSHA does. He is not law enforcement. OSHA is not going to send anybody to jail. They make findings, they fine, they can shut people down. And that's what they did here. They made findings and they fined the employer, the corporation, not the individual employees.
And when you're doing this, does OSHA have a requirement to look at fault of specific employees?
As part of our inspection process, we try to identify a root cause if we can. Whether an accident is caused because someone is falling asleep at the wheel or whatever the case might be, we do try to identify those things. In this scenario, we weren't necessarily able to identify any particular standout reason why an employee would be blamed.
So again, very good for Hannah Gutierrez. Now, OSHA guy number 2, I would never have called him. I don't know why the defense called him. I would never have called him. Let's see if I want to jump I think we're about to get to Cross here. I want to play a little bit of his Cross.
So what was in total bottom line here, the root cause that you found?
To summarize the entire report would be that
I was like, she better sit down after this. And then eventually she did. But I mean, this summarized it perfectly, exactly what the defense needed this witness for.
Rust Movie Productions identified a hazard, a workplace hazard, working with firearms, and they adopted firearm safety policies, but they totally failed to enforce them, train their employees on them, practice them, reference them, nothing. They adopted it and it stopped at the word adoption. Nothing further happened.
Okay. And
Boom. That's it. That's what I would start my closing argument with if I was the defense.
was it brought to their attention by Ms. Gutierrez and others that there were these deficiencies?
Safety concerns were raised regarding the policies listed in Safety Bulletin number 1 not being followed.
And what was Rust's response to those concerns that were raised by Ms. Gutierrez?
Again, they seem to have chosen to simply not respond.
And that's it. She does eventually sit down. I'm going to jump ahead a little bit and cross. So I thought it was a really good cross as well by the state. You didn't review all this other evidence that we have here at trial, the pictures, the videos, you didn't hire experts in firearms and consultants and do fingerprints and DNA. Also, he said, Hannah Gutierrez, did you know that she had 10 out of 12 days on set? She was the armor. And he's like, I thought it was only 8. He's like, well, what if I told you it was 10? He's like, that'd be news to me. So it shows that OSHA doesn't have all the information. They don't have all the resources, all the investigation that the state did. They don't have all the witnesses, experts, evidence, and testimony that the state has. So I thought he did a really good job cross-examining this witness. And then I want to play the end of his cross here.
Would be one of their many functions, yes.
Right. So if she failed to do that, then would she have contributed in this regard?
OSHA's opinion is that management has to enable the work.
I think I might have
And
missed.
inspected, it cannot be verified as a
Here we go.
on paragraph 13, the last sentence, unless a round is removed from a storage box or firearm and inspected, it cannot be verified as a dummy round. Do you believe that that is the function of an armorer to perform this inspection that you indicated on this report?
I believe that would be one of their many functions, yes.
Right. So if she failed to do that, then would she have contributed in this regard?
OSHA's opinion is that management has to enable the work to be done in the first place. So if she didn't do that, our question would be, why wasn't someone ensuring that she would do that? And thus we would turn back to management.
Okay.
It's almost like a
can I
little
just
too
back
much.
the fact that you're
It's almost a little too much. Like I said, if she was smoking weed and then coming in, it's like, well, why did management let her? It's like, well, at some point she's got to make the right decision.
looking at the employer primarily as the basis of your investigation, correct?
Correct.
All right. Do you agree that if Ms. Gutierrez loaded live ammunition into a firearm and then passed it off as a cold gun, that would be a workplace hazard?
Certainly.
All right. And then lastly, are you aware?
I probably would have sat down after that. If Ms. Gutierrez would have loaded live ammunition into a firearm and handed off that gun as a cold gun, she would have created a workplace hazard. He's like, yep. It's a really good cross-examination. It was short and sweet. And Vicky said, I'm sorry, but to me, it all comes down to who put the live round in the gun equals Hannah. I don't believe anyone messed with the bullets after she put them in the gun. And that's why this prosecutor asked this witness that question. If the facts are this, which we believe we have proven in trial they are, she would create the workplace hazard. And he agreed. Bodie said Peter is questioning a witness sort of like boxing. The boxing quote, everybody has a plan until they get hit in the face. It can be. I find that this quote is true when you have like corporate representatives. They think they know everything, blah, blah. And you're like, but none of that actually happened here. You guys have all these procedures, but you didn't follow any of them. And then they start, and they start to get on their back foot. Daria, is the question I have, is there a culture of negligence on sets typically? I don't know. I'm not a movie set expert, but it seems like there was a culture of that here. And if there is a culture of negligence, that's definitely not an excuse. It's not a good look. It's not something that bodes well in front of a jury usually. With firearms employees harassment for intimacy scenes, financial, I mean, I would guess that you have all sorts of these problems in all sorts of different corporations and companies. And that's something we got to fight against. Like lawyers fight against this type of stuff all the time. Shatter points. Regardless of management, Hannah knew that there was multiple types of ammunition. Clearly there was cross-contamination. She did nothing about that. I agree. And grabbing ammo out of her car and stuff like it's like, what's management supposed to do with that? How would giving her more time to inventory her ammunition have helped make her not make such a terrible decision? That's the tough part.
Where I believe you conducted an interview with Ms. Gutierrez, correct?
Correct.
And in that interview, she indicated to you that she asked 2 producers for additional training time, correct? You recall that?
I don't recall off the top of my head.
Okay. All right. Nothing further.
He was like, this guy does seem honest too. He's like, he was looking up like, did that happen? I don't remember. So we're going to listen to right the beginning of redirect. where she responds to that really good question by the prosecutor that he ended his cross on.
With that little hypothetical that Mr. Lewis just said, if Ms. Gutierrez had passed off a loaded gun as cold, would that be a workplace hazard? What if Rust had not allowed the armor sufficient time to inspect that gun and rushed her and instructed her specifically of what they wanted her to do? Whose fault would it be then? If question, so if in what Mr. Lewis had stated, if there was a gun passed off as cold, whose fault would it be, or whose responsibility would it be to ensure that the armor had sufficient time and resources to make that gun safe?
It's always the responsibility of management to supervise effectively and quality control effectively. If an employee is conducting a safety-related task, they pass it off as safe, and supervision does nothing with that, and they allow it to be implemented. Supervision's responsibility to double check that.
And was it also
It's funny that he can say that, right? Supervision's responsibility to double check that. It's not always. Like I can think of lots of situations where it's not. But here, they do say everybody should check it. Hall should have checked it. Baldwin should have checked it. Everybody should have checked it, but so should Hannah. And I thought this was a good sparring battle back and forth between these lawyers with this witness. Good questioning, getting good points across, good responses. This is what it's supposed to look like. I thought they did a really good job with this witness. I enjoyed watching this witness, this lawyering, this information come out. Then we get to the next OSHA guy, who is this guy's supervisor. This is what he looked like. Not that it matters what he looks like, but just in case you were watching the trial, this is who I'm talking about. He reviewed the last guy's report. OSHA is a completely unbiased third-party investigator. He believes his team's investigation was thorough. LOL. It's like he thought he did a great job and his team did a great job. They collected as much evidence as possible. I knew that was going to come up on cross since we already heard it on the last witness, that they didn't get this, that, and the other that state had. Oh, by the way, the defense attorney also on redirect asked the last witness, did you need all of that other stuff to make your opinion that the state said you didn't have? And he said, no. I find that hard to believe that it wouldn't have helped. He found no fault in their investigation, obviously. The law enforcement report was after their report was done, but they didn't need that to make their findings. He even says that what they do is different than what law enforcement does, which again, he probably thinks is helping his case. I think that's a point for the prosecution to show, listen, this is a completely different arena. They're doing something that doesn't even relate to what we're doing here, which you could argue it does or it doesn't. And he said he proposed $130K-ish fine, which is the statutory max, but they settled on 100, which is not the most in state history. And Phil said, do you think the prosecution should point out the contradiction about the highest fine in state history? I would say no, because A, they don't represent Rust Productions. They think Rust Productions screwed up too. So you don't want to be like, oh, it was only 100K or it was only the statutory max. You probably don't want to go there. I think it's really just if the jury picks up on any inconsistencies. Now, what you might say in closing argument is the defense is trying to hyperbolize everything. They're trying to confuse you. They're trying to blow smoke. They're trying to trick you. That's why they say stuff like this in opening, like highest fine in state history. And it turns out their own witnesses say that's not true. So they're trying to make certain things sound worse than they are, when at the end of the day, they know, everybody knows that testified. Hannah Gutierrez had a duty to check these guns, to handle these firearms, to be the last one to give it to Alec Baldwin, to not bring live ammunition on set, and she failed. And that failure caused a death. That's how you can probably mix it in, but I wouldn't make a big highlight of it. Maddie said, this feels weird still. I can't feel angry with Hannah Gutierrez without being 20 times angrier with the system that allowed this and those who aren't being amended. I don't know what you mean by amended, but again, can't forget, Hall's pled guilty to a misdemeanor. Baldwin's trial is coming up soon, so she's not the only one. I think she's one in the line of people that are culpable potentially, but I get where you're coming from. All right. On cross, again, I thought it was a good cross-examination. You don't do criminal investigations, right? Correct. He impeaches him with this pretrial interview, or at least he tries to, but the guy's like, nope, I didn't give it. Prosecutor, again, this was not great. He fumbled around with the wrong date 3 times. Eventually we get to the right date. I thought it was like 1 month ago. He said February 5th. I was like, this guy doesn't remember an interview from 1 month ago, but even November is only 3 months ago, or 4 months ago, I guess now. And he's like, this guy literally does not remember his own pretrial interview. But in his interview, apparently he said Hannah's actions contributed to the breakdown of safety on the set. I thought that was important. I thought that was great evidence by the state. It makes me think this guy should not have been called for the defense at all. I just would not have called him. He confirms that when you made your findings, you didn't have the law enforcement report, all the evidence we talked about that's been here in trial. He agreed. And then here, I thought this was another great ending to cross. And then we'll hear how the defense responds to it when they come back. Wait, sorry. 21, so 118. No. All right, I did the math wrong. 208. Okay. 33.
Filming of the Rust movie cameras.
No,
Did you engage the assistance of any expert armorers for your purposes of your investigation?
we didn't engage a contract. We had some brief discussions with potential experts, but we never actually engaged those experts.
You never relied on any of their opinions to inform your investigation?
No.
Okay. I know that you were asked some questions about determining fines against employers. Is it fair to say that OSHA's purview is not to assess fines against individual employees?
That's correct.
So is it also fair to say then that even if you found that there had been some concerning conduct by an employee, you wouldn't have fined that employee, correct?
Correct.
Thank you.
It's a great ending. He's like, you guys don't assess and fine individual employees. So you were never going to have Hannah Gutierrez named here as having fault in an OSHA report, which is why this is totally irrelevant to this criminal case. Now, he left that last part out, but that's what he's trying to say. And he's right about it. Francis said, this guy said the fine was over 130K, but they settled on 100. So maybe it was the highest awarded, just not paid. The last guy said no, that he has seen other fines similar to this. So I really don't think the defense has gotten that evidence out. It's just me personally, maybe I'm nitpicking. Okay, let's see how they deal with it immediately on redirect.
Nothing further.
And he sits down at the right time, that prosecutor, after cross-examining these witnesses.
But would you have said in your report that a specific employee failed to do something if that's what you determined?
Leading, but defense attorneys almost always lead on redirect because they're so used to crossing witnesses.
In most cases, no.
It's like, let me hear that again. So she stood up and she thought she was going to get a response like, listen, you could have if you wanted to, right? He's like, no. And he kind of contradicts the last witness, but he's the boss. And so the defense basically doubled down on their mistake. One thing I noticed with this female defense attorney is even when she gets a bad answer, because she has asked a lot of questions that I don't think she knew what the answer was going to be, and sometimes it doesn't go her way. But what I will say is she doesn't get flustered. She just kind of moves on. It's almost like if you weren't paying attention as a jury, you wouldn't realize that it was a bad answer for her, which is a good skill to have as a defense attorney.
Employee failed. Redirect.
All right, let's listen to her question again.
But would you have said in your report that a specific employee failed to do something if that's what you determined?
In most cases, no.
It's like if you saw that a specific employee did screw up, you would have said that in the report. He's like, most cases, no. So it's not great, right? But he did talk about how Rust did fail to provide adequate time and authority for the armorer in this case. Again, giving the jury potentially something to hold on to if they want to say she couldn't perform her duty, therefore she did not breach her duty, but instead management forced her to breach her duty. Then we heard from this guy who is a private investigator, former law enforcement, an expert in the quality of law enforcement investigation. And I'm going to summarize where he's at so far because we're in the middle of his cross-examination. But basically, the defense is like, what issues did you see? Well, they didn't keep witnesses segregated. They could have talked to each other. People could have changed their stories. People could have deleted things on their phones. People could have left the scene. The cart was moved. It shouldn't have been. Touched the firearm ungloved. We can't really even confirm that the bullet came from this gun and rounds were thrown away. They should have gone back and checked a month later. Oh, and it was also such a problem that they waited a month and checked Seth Kenney. Again, those always seem contradicting. It's like, well, if you want them to go back and check the trash for those bullets, you should have also wanted them to execute the fire or the search warrant on Seth Kenney as soon as it was legitimate and able to do so, which seemed to be a month. Now, you can say they should have done it faster, which is fine, but there are steps you have to go through and hoops you have to jump through before stuff like that happens. I really don't think literally anything that he said seemed like a big deal, except maybe segregate the witnesses. He also said stuff like, oh, you should have absolutely gotten Alec Baldwin's phone from the jump. It was so unfair that Hannah Gutierrez was put in the cop car and not anybody else. They were allowed to, move freely. It was strange how the officer asked for the weapon and the armor and not the shooter. And then concerns about, interviewing somebody after a traumatic situation. She definitely should have been checked by EMT first. I personally thought this guy was a nothing burger. And the state, we're back to the female prosecutor, comes up and is like, you're a defense investigator, right? Paid to help them, right? Touching a firearm ungloved, not matching the bullet to the gun. Am I missing something here? Or are you under the impression we don't know who pulled the trigger? I shouldn't say who pulled the trigger because she didn't say that. Who held the firearm when it went off, and that the projectile did in fact come from this gun. That's not in question here. You realize that, right? Because again, when you can start to make defense attorneys look like they're grasping at straws or throwing anything against the wall, seeing what sticks, it's not usually good for them. And to me, saying, oh, the way they handled this firearm, anybody's fingerprints could have been on it. It's like, I don't care if everybody's fingerprints were on it. We know Alec Baldwin was holding it when it went off. We know Hannah Gutierrez at least handed it to Dave Halls, and Dave Halls, so all these guys touched the gun. So it didn't matter. And the fire, and she's like, the projectile, we couldn't test and match to this gun, right? Right. Is that because it went through somebody killing them and then it lodged into the shoulder of another person? Again, not good facts that you want to come out if you're the defense, and they open the door to them. Also, we know where this box is from because it came from Hannah Gutierrez. So a lot of the information you're acting like is muddy is not muddy because the defendant gave us her own statements that law enforcement used that ended up being true to basically be used against her. So to come up here and be like, oh, it wasn't a great investigation, that may work really well in some cases, and it really does. It works really well in some cases. But in this case, what did the investigators really figure out? To me, it was served on a platter with statements made by everybody. Everybody involved in this case, Zachary, Baldwin, Halls, Kenney, Gutierrez, everybody was given statements. That, along with the actual ammunition, videos, pictures, everything we had, it's like, what investigations really had to be done? We needed to know what the duty of an armorer was, what happened with that firearm, where the live ammo was, how it got on set is basically the only thing the investigation could have produced, and it produced some circumstantial evidence it was from Hannah Gutierrez and not from Kenney or Billy Ray. That's about all the investigation brought forth, in my opinion. So this guy is still on the stand now. Lunch break ending in about 10 or 15 minutes. And look, in 45 minutes, we got through a whole extra day or through a whole day of trial. And now you guys are all caught up to speed without having to watch all of it. Mary said, check and recheck when working with ammunition and two people doing it. I agree. And that's the point. This was the point of the state's experts. And the jury should remember it and make their decision. Beam uses, if she is found guilty, would that help Baldwin in his case? I've gone both ways on how guilty could help, guilty could hurt, how not guilty could help, and not guilty could hurt his case. So I'm not really sure one really does any better or worse than another for him. Moon Goddess. Question, Peter, do you think this will make any changes in the future for Hollywood and how they do things, especially in regards to handling guns? I do. And I've heard rumblings that it already has. I hope that it will change things, and I think that it will. Mammy, if so many people were complaining about the safety issues, wasn't it management position to fire her? So I don't think that we have documented evidence that there were so many complaints about gun safety. And Halls and Zachary basically said, we think she did a pretty good job outside of a couple accidental discharges. Steffi B said, Peter, will you be covering the Jason, I think it's James Crumbly trial too? Absolutely. I should say, if you guys are interested, you're interested in Jennifer Crumbly, if you're interested in James Crumbly, I will be covering that one as well. I do think this trial is going to wind down here pretty soon. I think we might be done with Rust this week. And I hope we are. That'd be perfect timing for covering James Crumbly's case. If both are going on at once, I don't know which one will take more of my time, but we'll figure it out one way or the other of a way to follow most. I'm obviously not going to be able to follow 2 trials at once completely. So we will figure out a way to make it happen. Hopefully this trial winds down as they're picking a jury today in James Crumbly's case. All right. Yeah, everybody's saying absolutely are interested in James Crumbly, and everybody's covering Rust, so you're not going to miss out on Rust. People will be covering it. I don't think that many people covered the Crumbly cases, so I will definitely be on that. So make sure you guys subscribe and hit that reminder bell for James Crumbly, because I'm going to jump on that one probably from opening statements on and doing breakdowns and recaps for you probably at night, where we think we may have gotten the internet figured out at the house with new fiber or whatever internet. So we'll see. But I appreciate you guys joining me as always. Make sure you hit that like button on this video and continue to send me what you're interested in on Instagram and Twitter at Tragos Law and at Lawyer You Know, so we can continue these conversations. I appreciate everybody reaching out to me and joining me for this case. It's always fun to hang out with you guys, answer your questions, and get your perspectives as potential jurors. But for now, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.